Welcome. This is another session in our SME presentation series. My name is Alicia Wood. I'll be presenting on what we've coined the ABCs of debt recovery. Start with the acknowledgement of country. We acknowledge that this land that we meet on today is the traditional land of the Kaurna people and that we respect their spiritual relationship with their country. We also acknowledge the Kaurna people as the custodians of the Adelaide region, that their cultural and heritage beliefs are still as important to the living Kaurna people today. We also pay our respects to the cultural authority of the Aboriginal people visiting and attending from other areas of South Australia. So I'm from our dispute resolution team. We're a full service commercial firm. Welcome to the people online. We're a full service commercial firm. So some of the matters that I'll touch on today, you might see other people within this firm if you were getting assistance with drafting of contracts, for instance, but as I say, I'm the dispute resolution team. So if you reach out for debt enforcement, you may need me or someone else in our team. I'll just do a bit of an overview on what I'll cover today. So contracting and getting your contract terms correct are key to debt enforcement. So I'll detail some of the essential parts of that. And I'll address self-help remedies, which are steps that you can explore to avoid legal costs and steps that we would expect you to have explored before you come to a lawyer, and steps you should take to then identify whether it's necessary to see a lawyer and take a series, if you will, steps. Then what's involved in seeing a lawyer, what you should bring to when you see a lawyer, and the different sorts of court proceedings you might engage in if you are enforcing debt, and then the different enforcement processes that are available. So first, cover contracting. While this is a presentation on debt enforcement, contracting is the essential first step that you need to get right. So if you don't have a good pro forma contract in your business or terms and conditions on your website, which your invoices refer to, then that's an essential step that you ought to come and get legal advice on. And it might just be a pro forma that you roll out with each client. And it has a guide to essential things that you ought to consider every time you engage a new client, and just like to address some of those because they are key when you come to see a lawyer to enforce a debt, and that will be the first thing that I'll be looking at. So your contracts, or if you don't have a contract, your invoices ought to properly record who the party is that you're contracting with. And I don't say that lightly because you'd be surprised how many times we see invoices that aren't even labelled addressed to a legal entity. So a business name is, of course, not a legal entity. You need to identify whether an individual owns that business name or a company owns that business name. And it's next to free to conduct an asset company or business name search to identify who the correct legal entity is. We mustn't I can't stress enough how important it is to not overlook that essential step when you're contracting or entering into a new arrangement with a new supplier or party. So you might also make some basic inquiries about the nature of the person or entity that you're dealing with, and that again is a next to free sort of a series of searches you can conduct to identify if they have any assets. It wouldn't be uncommon for a business to have a trading entity, for instance, which has only its cash flow, and then its assets, properties that it may own, are in a separate entity. So you want to ensure that if you're just dealing with a trading entity, you've ensured you have something like directors' guarantees, for instance, and the right in your standard terms to register a caveat over any assets that might be a real property that might be held, or but crucially, directors' guarantees. If the director will enter into them to protect you if the party defaults. And in our experience, when a director is faced with a claim against them personally, they're much more likely to pay than if they're just dealing with a demand from a company. And it gives us that second level of enforcement in circumstances where the company gets wound up. So back to essential terms, you need to make sure you record the essential payment terms and rates and how much is going to be charged, so there's not a dispute when you come to me as to whether what was charged is what was agreed. Don't overlook including a provision for interest. Don't overlook including a provision for enforcement costs, so that when we're drafting a claim for you, I can claim the interest that you're entitled to, and that you're entitled to recover your costs against the party who failed to pay you. Consider doing searches, including PPSR searches for assets that they hold, and similarly include a provision that permits you to enter and register PPSR registration over goods that you're, for instance, holding a retention of title clause or goods that are subject to a lease if that's the nature of business. It's probably a topic in itself to talk about the PPSR registration, so the Personal Property Securities Act, but it does permit parties to seize goods, and it will give you some priority if that company goes into liquidation. So it's something that really should be in your standard terms, depending on the type of business that you're dealing with. This slide will be prepared for me with some nice smiley faces there about good contracts and bad contracts. So a good contract will include all those provisions that I've talked about. A bad contract will maybe not exist. Keep in mind that even an oral agreement is a contract. So if you come to me and say, oh, you made an agreement on this day when we met, I'm like, that's great. So what are the terms? Oh, we should document them, but I think they were this. And that would be an example of a bad contract that you didn't end up documenting, and it really is fairly straightforward. A contract could even be just reporting in an email after you've met with someone if you've made an engagement. Everything is a contract. As I say, a handshake is a contract, an agreement to provide services for money, and you start providing services. Even if you haven't documented it, you've entered into a contract. And so just going through those again, ensuring you have identified the parties, you've got your payment terms, you've ensured you've included provision for any security or director guarantees, and considered whether there's an entitlement to PPSR registrations, or provided indemnities, and that the last one there that you've provided a term in your contract as to when termination can be triggered. Just address briefly self-help remedy. These days, there's often software that's easily flow into your business, which sets up automatic reminders and basic pro forma letters, which go out on X number of days when a client hasn't paid, and then another one that goes like a final notice. And we see these things all the time. If you don't have that software, then it's easy enough to set up those pro formas that go out. And they are initial self-help remedy steps that you ought to take to put someone on notice that you're mindful of their going out of terms, the liability going out of terms. So they would be in the nature of informal correspondence. I can't stress enough the importance of documenting these efforts to ensure payments made. So keep a copy of what you've said. If you call someone, jot down a note of it, because when you come to see them, then have a record of the efforts that you've made to enforce the liability, and that's all relevant, discoverable is the word we use. It's evidence that's produced to the court if it's necessary for you to prove the liability and the fact that it wasn't disputed, which is crucial. So let's say something we commonly see is the manufacturing of defects or complaints because you're chasing them for payment. So if you present me with a number of demands for payment and there's been no criticism of your work, that's relevant to showing late invention of a liability. There might also be an admission, like, I'm sorry, they might respond and say, sorry, I haven't paid yet, I just need some more time to pay. It's an admission that they owe the money, and it also shows there's no complaint raised about the work. So there's some examples of why your initial communications before you see a lawyer might be really crucial to our efforts to enforce a debt after. This is that basic debt recovery. Document it, follow it with a phone call. Document it, follow it with a phone call. Offer discounts to secure early payment. Offer waiving interest to secure early payment. They're just basic steps that might seem obvious, but they are really effective efforts to secure payment in our experience. What you mustn't do is break the laws, harass someone, contact people outside of business hours, arrive at their home unannounced, or be threatening or indeed trespass on their property. They seem obvious, but all right, so I've started addressing this topic already. When you see a lawyer, these are the sort of documents that you would need to bring in. So you have an initial meeting, and We offer a free letter of demand. So that's something I encourage as well. So you might have gone through your letterhead letters and phone calls, but you'd be surprised how many times people will pay when they get a letter from on a lawyer's letterhead. And we offer a free letter of so it's something worth exploring if you're finding someone is being reluctant or avoiding putting their head in the sand, engaging with you. So when you come and see us, what you would need to bring is the contract, whether that is magic pro forma that we've prepared for you or that you've generated, or if it's invoices or the emails that comprise the agreement that you made, evidence of what you've charged, so the invoices, evidence of services provided, such as that might exist, and evidence of any payments made, and any of your communications that you've had with the debtor, sort of things that will scrutinise to consider any whether the debt is disputed or whether there's likely to be a defence raised in the proceedings, and they're all relevant considerations for the sort of enforcement step that we consider. So when we first review the information that you give us, we'll also conduct searches about the party that you're intending to sue, basic searches on ASIC, who their directors are, what assets are held by the company or individual, real property searches and PPSR searches, so that we can advise you on your real recoverability. We'll also consider any interim steps that might be necessary. For instance, if you tell us that they seem to have ceased trading but have set up in another place, it's what we call phoenixing activity, or if you, depending on the sort of person or company that you're dealing with, if you are concerned that they're perhaps leaving the country or wrapped up in business, there might be interim remedies such as freezing orders that we might explore with you. If you're providing services in the building and construction industry, there might also be steps that you can take under the SOPA Act, which is the Building and Construction Industry Security of Payment Act. That's an act that was brought in to assist particularly subcontractors in the building industry who are being paid. They can serve what's called a payment claim, and if a payment schedule is not served in accordance with the timeframe under the Act, then the party serving the payment claim is entitled to enter judgment under the Act. And it's an act that was brought in because the court system was clogged up with construction matters that seem to include defences and counterclaims about alleged defects and delays, and some of which was spurious, but caused the matters to become complex and bogged down in circumstances where perhaps they were disingenuous. So it doesn't prevent a party from raising counterclaims later on, but they have to issue separate proceedings. It more just secures early payment, just like a pay now, argue later sort of act. Now, when we consider what steps might be appropriate for you, if you're dealing with a company and that owes money and it's unlikely to be disputed, we might simply serve a demand under the Corporations Act and then proceed down a winding up application, which presently is $4,000 minimum. It used to be $2,000. So it's a as long as the debt's over $4,000, we might just serve a accredited statutory demand, and that would give rise to a presumption of insolvency if they fail to pay within 21 days. And then we can launch into an application to wind up the company. We wouldn't do that if there was evidence of a dispute about the debt, but if where it's clear cut, that's permitted. Otherwise, if we're securing a judgment for you, for instance, if you're seeking to enforce a liability against an individual, you can't bankrupt them without a court order, so we might need to get a court order. Also, bankruptcy requires a liability of is it $10,000? $10,000, yep, minimum of $10,000. So if it's necessary for us to get a judgment, we would issue either a final notice or a pre-action notice. So a final notice is where you have a reasonable belief that the claim is uncontested or not genuinely contestable. No evidence of defects or disputes about the work, no complaints about delay in the provision of services, that sort of things. If it's clear cut and you can't see a reason why they haven't paid, then we go straight to a final notice. The difference being that the court rules require for a pre-action claim where there is a dispute about the nature of the debt and the services provided, they require us to go through a number of steps, pre-action steps, which bring the parties together and try and resolve the dispute before court proceedings are issued. So a pre-action claim requires us to set out the nature of your debt or your claim. It must include an offer, must provide enough information or documents with it so that the other side understands what we're issuing a claim about, and it must invite a meeting. So it's like it's a pre-action meeting. The other side's are required to send a pre-action response within 21 days, and that pre-action meeting usually occurs within 28 days of the pre-action claim being served. And then a pre-action meeting, it's not usually conducted like a mediation, would just be conducted informally by the solicitors and the parties if the other side obtain a solicitor. So it's almost more like an informal settlement conference, and we would just conduct them here, and hopefully they end the matter being resolved rather than the need for issuing proceedings. If proceedings are issued in respect of the recovery of a debt, if the other side does not file a defence within 28 days, you're permitted to file judgment, which is called default judgment, as long as we can establish that the debtor was validly served. If they do file a defence and the defence is spurious or has no basis, then we're still able to apply for something called summary judgment. And that's permitted where there are no reasonable grounds for defence, and we need to establish that before the court. If the debt is contested, the process may be somewhat longer depending on how complex the matter is, because it will require a period in which the parties produce evidence, and then there might be mediation, expert evidence if that's necessary, but hopefully not if it's a straightforward debt matter. But if there's a dispute about defects or so forth, there might very well be if it's a building matter or require some form of expert to assess whether the services provided were adequate. I'm keeping this as simple as possible, noting that it's a debt recovery seminar. So then assuming that we then have judgment, we would move on to taking steps to enforce judgment. There's like the default judgment and summary judgment with contested proceedings, steps that are involved. I should say, even if you don't resolve the matter in the pre-action meeting I discussed before, a dispute can settle at any point in time. So you're able to send without prejudice letters and offers, file offers in court, and try and settle your disputes at any point in court proceedings. The court will usually encourage parties to engage in mediation, particularly if it's looking like it will go to trial. And we would generally say that only about 5% of matters actually go to trial. So it's rare that they're contested enough that they would go to trial. It's okay. The regress them. So at the point that we have judgment, subject to the type of respondent we're talking about, whether it's an individual or a company, for instance, we would then again consider the financial position of that company or individual before advising you on what sort of recovery steps you would take, because applications to wind up a company or bankrupt an individual are not free. They figure in front of me, but it's like $3,000 or $4,000, maybe more too, for the active court fees. So it's not a free service that's involved, but it does seize immediate control of that individual or company's assets and should permit a recovery to you. So via the court process, the Enforcement of Judgments Act, there are a number of steps that you can take instead of exploring bankruptcy or winding up proceedings. And they are all steps that we can assist you with. Depends also on the court that you're in. So if you're dealing with a debt that's under $12,000, you'll be in the minor civil jurisdiction, and that's what we might call a people's court. You can send a lawyer along to the initial hearings, but generally you would represent yourself in the trial, and the judge or magistrate rather would assist you in the conducting of that trial if in the unlikely event that it actually went to trial. Anything between 12,000 and 100,000 is still in our lower court, in the magistrate's court. Above 100,000 is in our district or supreme courts. In terms of debt recovery, they're probably the courts you're going to be in. So under our court rules, if you secure a judgment, you then may explore with your solicitor the following sort of steps. One avenue might be issuing an investigation summons. If the debt is under 12,000, which is our minor civil jurisdiction, you are more limited in the number of enforcement steps that we have available under our court rules. And these are generally the investigation or examination summons, and that's where we issue we apply to court, we issue a summons. It's served by the court sheriff on the individual, and they are required to come into court where they're cross-examined as to their capacity to pay the debt. It's really straightforward, short hearing, and there's very limited cost involved in conducting those examinations. And if the court agrees that there is capacity to pay, they might be required to enter into a payment arrangement, which is enforced by the court, for example, an instalment order. If a person is served with an examination summons and fails to come to court, they will be issued with a warrant for their arrest. I think there's only X number of hours that the court can hold them, so maybe 24 or 48 hours, depending on the court's availability, they might be released again and they're required to come back. But that is the courts do assist us to secure the person's attendance at court for the purposes of examination. And any of these steps are usually prompt payment. Like, people panic when they receive a requirement, a summons that they're required to come into court, give evidence about their capacity to pay. If they've otherwise ignored the final notice and the claim, didn't file a defence, now they've got judgment and they receive an examination which requires them to come to court, that in which they could be arrested. You find that any number of these steps will secure payment in our experience. And the other options that might be worth exploring in the court enforcement processes under the rules are a warrant of sale. So if the individual or company that you are pursuing a debt for owns real property, there are steps that can be taken to force the sale of their property to secure payment, and that's a fairly straightforward process that we engage in fairly regularly. And the sheriff would conduct a sale of that property if the and it will result in them being removed from their property and this property being sold as a distressed asset, unfortunately for them, and then the proceeds of the sale being returned to that individual if they don't have if they have any equity left in after the enforcement of those debts. If one of the things I touched on in terms of your contracting terms, you can include in your contract an entitlement to register a caveat over a person's property, which provides you with security. If you haven't secured that, or if you haven't included that sort of clause, there is something called a charging order that the court can order, which attaches to real property. If you've obtained judgment and you can identify that the debtor has property that you can attach the charging order to, and these act much the same as a caveat. So we'll just discuss bankruptcy. I'm doing well at keeping up with my slides, aren't I? So bankruptcy is an action that you would take against individuals. It requires that you've already gone through those steps I've spoken about to get a judgment. Once you have a judgment in and it's over $10,000 and not more than 6 years old, you can apply to bankrupt someone. The first steps are to issue a formal bankruptcy notice, which requires service, personal service. We have a team within our dispute resolution team. It tends to be with me, including currently, to maintain the cost for you. So there's about which fits which, but the bankruptcy notice must be served and they need to pay it within 21 days or apply to set it aside, failing which you can serve a creditor's petition and apply for a sequestration order, which is a winding up order. So the process of bankruptcy involves a trustee in bankruptcy being appointed to manage the person's affairs. The trustee has power to take possession of and sell the assets of the bankrupt. The bankrupt's home is likely to be sold, subject to the level of equity available and the preferences of any first registered mortgagees and any rights of any other party, such as co-owners, and the assets of the bankrupt. Bankrupt is usually entitled to keep certain assets subject to their personal circumstances and whether they have any dependents and the needs of those dependents and the age of those dependents, but they're otherwise permitted to keep their household and personal items, their income up to an indexed amount, which again varies depending on the number of dependents they might have, their tools to earn income, their vehicle, where any unfinanced portion is not more than about 8,500. Most funds in superannuation they're permitted to keep, and assets that they hold on trust for their children that can be established. Again, any of these notices usually prompt someone to pay. In the unlikely event that they haven't paid after being served with court proceedings, a fund notice or court proceedings, or the judgment. Once they receive a bankruptcy notice, that's a fairly crucial notice, and the cost here is fairly minimal. The filing fees, the court fees are around here. So the bankruptcy notice is a fairly cheap, again, enforcement step that does make people respond in our experience. It is a serious consequence to be bankrupted, and I find that most people work fairly hard to avoid it. And if they haven't previously drawn on ability to pay a debt, then they will do to avoid bankruptcy. If someone's bankrupted, they obviously have restrictions on overseas travel without the consent of their trustee, can't apply for credit easily, or enter into any other commercial arrangement without disclosing their bankruptcy, such as hire, purchase, or rental accommodation. They cannot act as a director while they're bankrupt. And their name will be permanently recorded on the National Personal Insolvency Index. People may, if you're genuinely dealing with someone who can't pay their debts, they can voluntarily file for bankruptcy, and that would have the effect of staying any efforts you may take to enforce your debt. So it is something that people do. So they'd be engaging with us and they'd be saying, can I have some more time? I'm exploring whether I am going to enter into voluntary bankruptcy. It doesn't mean the end of the road for you. You might still then wait in line and communicate with their trustee in bankruptcy, and you may still make a recovery. It's that their assets need to be sold and with the assistance of a trustee in bankruptcy to secure payment to you. So winding up proceedings. As I mentioned before, under the Corporations Act, there is a document called a statutory demand, and it's quite a formal-looking document. Again, when the company receives that statutory demand, we generally experience that they will take steps to secure payment for you. They must act within 21 days, or a presumption of insolvency arises, and by must act, it's a fairly serious step. They need to apply to court. They must file their application to court within 21 days to set aside the statutory demand. For instance, on grounds that the debt is not due or that they have a genuine dispute about the debt. And in the event that no steps are taken, then an application to wind up the company can be made. Again, that involves the appointment of a liquidator, similar insolvency practitioner who, like Nathan, who's improved. To a little plug for you, Nathan. Saying insolvency practitioners are routinely acting in the recovery of assets in respect of individuals and companies, and they will take over recovery of the debt for you. Issuing a statutory demand is something we routinely do, and it's a nominal expense. It is the court fees and the process of actually applying to wind up a company that's going to be more expensive if, again, this other more serious step doesn't result in payment. So just recapping, to bankrupt an individual, you do need a judgment to bring winding up proceedings. You can do that as long as the debt is over $4,000, liability is owed by a company, and you're not aware of any general dispute about the nature of debt. All right. No other specific questions about any of those? No? Anything you want me to recap on?
So within the context of a company application, where do deeds of company arrangement and administrations fit in?
So, okay, and by way of example, a matter recently went into winding up, and it was a company within a company group. And thanks for the question. And it turned out that that particular company held licenses which were crucial to the company group. So the directors applied to the court to move the company, to terminate the liquidation, move the company into administration with a view to entering into a DOCA, which is a deed of company arrangement. For those who aren't familiar with it, pursuant to which funds were provided to the creditors, including unsecured creditors, particularly unsecured creditors. And then that lifts the company, has the effect of lifting it out of administration after the terms of the DOCA are complete, and the company can continue trading and is returned to the directors. But it does deal with all of the blocks that arose at the time that or prior to the administration order.
And another piece of the recollection story might be straining for rent. I think we're publishing something, I'm sure we all have, which enables a landlord to take possession of goods and chattels plant within leased premises, sell them.
Indeed.
Similar, I guess, to what? What's that similar to? Probably some sort of charging order, I suppose.
Yes.
So that's more in the context of a landlord or tenant, but it's still just debt, namely rent.
Yes. But like I outlined at the start of the presentation, if you've secured when you first come to see a lawyer, if you've created security by caveat or director's guarantees, you're in a much better position to enforce the liability than someone who just comes to us without any form of security involved in the terms of the contract. So it would be standard terms that we would draft that would have, when you're dealing with a company, for instance, that the director is also personally liable if the company defaults, and that on the event of default, you're permitted to lodge a caveat or even at any stage against any property that's owned by that entity. And that gives you that ability to seize the assets. Sorry, not seize the assets, that's PPSR, but it gives you that leverage above other creditors, particularly if you've taken steps to register your caveat ahead of time. The caveats register with priority, similar to mortgages.
Just perhaps one suggestion about the very first stage where you talked about sending out letters of demand. You do need to be a little bit careful about what you say in your letters of demand to people. What you don't want to happen is that you write to them and you say something like, there's a lot of other creditors chasing you. We think you're insolvent. You need to pay us this money straight away.
Yeah.
And then they pay you. Then you've got a problem if the company does go into liquidation. Then it might become a criminal's claim. So you want to...
Meaning that it might be clawed back.
Yeah, it might be clawed back by the liquidator. So you want to sort of play dumb a little bit and just say that you owe us this money, you need to pay us straight away, and don't say anything about the surrounding circumstances that you might know about. You just stay quiet about that.
Yeah, because that's a relevant factor to whether it'll be clawed back. Yeah.
If you get the money and you can show that you got it without any knowledge that the company was insolvent, then you've got a good chance of defeating any claim, any criminal claim might be made.
Yeah. So your demand letter really should just state, this is, we provided these services on this date. We invoice you on this date. It's this many days out of terms. We're entitled to charge interest and recover our costs. But if you need to pay by X date, otherwise we will refer this to a lawyer. That's sort of just as simple as that, nothing more than those sort of.
Would you say that there's a difference between a director's guarantee and a personal guarantee?
Well, one No, it's a guarantee. Thanks for the question. A guarantee is a very serious document that can be challenged on many grounds and an important presentation in itself. But when it's something that you should have drafted by a lawyer, it'd be a director's guarantee if it's signed by an individual who is a director. Anyone can provide a guarantee on behalf of someone else. Guarantees are provided by individuals usually, and in this context, that's what I was referring to.
Yeah.
It can be set aside or challenged on the basis, for instance, that a person didn't understand what they were entering into or didn't have an opportunity to, or were pressured into signing it, or didn't have an opportunity to obtain independent legal advice. So you protect yourself there by making sure that it's not hidden in the terms of your contract, that it's standalone, that it's in bold, that there's a separate signing document, which isn't, so it isn't just director signing in personal capacity and director signing on behalf of the company. You'd have a standalone document which says director's guarantee. You would also have a clause in the guarantee, for instance, that said, I confirm that I've had an opportunity to seek independent legal advice in respect of the entry into this guarantee. And as that best practice would be to have documented in your file that you provided the contract to the director on X date.
Yeah.
So like a cover email would be enough. And then that they signed it X number of days later, because it shows that they weren't forced to sign it, required to sign it the day they came in. So it shows there was a number of days in which they could have gone away and taken it away and sort of like legal advice on it.
And do you need the original back? Because a lot of things are getting signed online, but what about having that?
No,
You don't need the original.
no. Ideally, you hold the original, but in terms of guarantees, if there was a question, it would be good to hold the original in case someone alleged that it's not their signature. But
Legally, you don't need
no,
it.
it's okay to hold a copy.
I just want a copy.
Because we frequently receive documents now electronically.
Yeah.
It's the sort of serious document that I would encourage them to post it back to me if in its original form. Yeah, but it's not uncommon to see terms of engagement or which have a director's guarantee in them only in electronic form. Yeah. The more evidence you have around, you can hear from the things I'm saying, the more evidence you have around that individual having considered the material and engaged with someone and considered the guarantee and had it drawn to their attention, the better. So notes of a meeting with them about entering into the guarantee be useful.
If you're dealing with someone who's got mental health issues, drug issues, that whole spectrum of things, and so you're not really up with what the impact is going to be and how that's going to be reacted to.
Yeah. Do you mean in terms of entering into a contract with that person?
Pardon?
Do you mean in terms of entering into a contract with someone?
If you've been in the contract and now you're trying to formalise the payment.
Also, you have a contractual arrangement with someone and then you suspect that they're mentally unwell. Is that the question?
Well, they're now unwell, so we're just negotiating steps.
And they owe money.
Yeah, they owe money, yes.
Do they have capacity?
I believe they do. But I don't know what's holding up the process, but I'm now at the point of asking, is there something that I don't know which is, preventing you from finalising this? So I have given him a date now, and I have said if we do not resolve this, then I will get a lawyer letter of demand.
It's very hard to know without the context.
That's right, yes. Yeah.
But certainly
I've advised him though to actually seek some help as well. Apart from himself, he's working on his own, and I need to get some confirmation from someone else about what is going on with him.
Yeah, maybe you could suggest a meeting where you can make that assessment or invite a next of kin. Or it depends on the context.
He's been very reluctant to give me any
information. Yeah, I mean, in different contexts, that's another consideration, whether you're contracting with someone who has capacity
Yeah.
So then in which circumstance you might consider requesting, we would certainly consider requesting whether they have a power of attorney and taking a copy of that power of attorney. Doing with that. Yeah. Whose capacity might be compromised, for instance. You can't enter into a contract with someone whose capacity issues. It will be set aside, risk being set aside.
Oh, the capacity was there at the beginning, but something's happened since too.
Yeah, that makes it very difficult for you to enforce the debt, to be frank. I mean, what do you think, Joe?
Oh,
It's a hard.
got good understanding that they lack capacity.
That's right.
Yeah,
At some stage, they're going to have to.
it's for them to raise. Yeah, you can assume that they're okay until and it, I mean, it's a bit awkward, but people have, as we all know, people have every excuse under the sun for why they can't pay. You know, when you're actually when our paralegals are doing debt enforcement, I've seen it all. So, if, as Joe says, they just plough on until you really see a genuine reason why they can't pay. Any other questions? So I'm going to go too quickly.
It's easy enough to chase someone through the debt from overseas.
No,
No.
not as easy.
No.
Yeah, so even within Australia, it depends on so the first question is where did the debt arise? Do you mean, so are we looking at where the contract was formed? Or do you mean it was formed here but they've moved overseas?
No, because there's the client's overseas and I've purchased something for them on their behalf over here, so as a buyer's agent.
Yeah.
So, and now they're not paying.
So you purchased something for
So
them.
they're an expat, yeah.
Yeah.
So they're working overseas.
Well, you need to serve them the trouble.
Yeah.
So you issue proceedings here, but you need to serve them, and then there are reciprocal relationships between different countries as to how you would serve them. Unless the contract's formed.
Unless they come back to Australia,
Yes.
then you can serve them.
Right. Yeah, it's a tricky one.
It can be quite difficult to serve.
Yeah.
Proceedings. Where you issue the proceeding, you issue because the contract's here for Australia. That's easy enough to do, issue proceedings.
Okay.
It's just like door. But then you've got to serve them.
Yeah.
And that can be quite difficult because depending on the country they're in, they might be under what's called the Hague Convention.
Right.
That gives you methodology to serve overseas. Depending on the country in a Hague Convention, it can be easier, it can be hard. I've got one at the moment where we're serving over in Italy, and it's now been 14 months since it got sent from the court, Supreme Court here, the Supreme Court over there, the Supreme Court has served them, they still haven't done it. So, but there are other methods of serving. So we've served under a different method. Now they're aware of it, and now they're complaining in our courts here that we didn't follow the right process. So I think on that one, $12,700. So it's worth having a fine. But you know, you're doing it about $3,000.
Yeah. Is there any other questions, or I can detail any other part? Thank you. All right. Thank you all for coming.